Okay, good afternoon, everyone. Again, this is Jordan Schwartz from Conn Maciel, and I am here with my colleague, Lindsay DeSalvo, and we're talking to you about the changing landscape of anti-discrimination laws. This meeting is being recorded, and feel free to ask questions throughout the presentation. There's a chat box in the lower left-hand corner of your screen, and Lindsay and I will do our best to address as many questions as we can get to. Again, please mute your lines if you are on the phone, so they're not a distraction to everyone attending the webinar. A little bit of background about me. I'm a partner in the Labor and Employment Group here at Conn Maciel Carey, and I represent employers in all aspects of the employment relationship. I counsel employers on compliance with all federal and state law to deal with hiring, firing, discipline, internal investigations. Also, if employers get dragged into litigation, I defend employers at both the state and federal level and really cover their gamut. I do a lot of AIDS discrimination, a lot of Americans with Disability Act, wage and hour with the Fair Labor Standards Act, and Title VII. And I also advise both unionized and non-unionized workplaces regarding employers' rights under the National Labor Relations Act.
Good afternoon, everyone. My name is Lindsay DeSalvo, and I'm an associate here at Conn Maciel Carey. I also represent employers in a number of matters, including wage and hour disputes, as well as discrimination claims. I assist employers with reviewing and revising employee handbooks, which will be important aspects of what we talk about today. And I also help employers with preparing both separation and settlement agreements.
Great, thanks, Lindsay. So we're going to get started. Just so you know what to expect here, for the first probably 15 or 20 minutes or so, I'll be talking about what's going on with discrimination involving transgender issues, and also get into a little bit of what the courts are doing with sexual orientation, and that's an ever-changing area of the law. Then Lindsay will jump in and talk about what's going on with pregnancy discrimination and light-duty accommodation issues, and she'll also discuss ban-the-box issues. And then I'll come back and finish up and talk about what's going on from a social media perspective, and as employers, what you should and should not be permitting if you see employees talking about your company or complaining or doing really anything related to their job on social media. And again, if everyone can please mute their phones, that would really help the presentation going forward. I know some people are really having a hard time hearing because all the lines are not muted. So thank you for your cooperation in that. Okay, let's talk about transgender issues. And really what I need to do first is kind of throw out some definitions and explanations for you before we delve into what you should or should not be doing as an employer. Because a lot of these terms really get thrown about, but what you need to really understand some of these terms before you can determine as an employer how you should be addressing these issues. Again, please mute your lines. We're hearing a lot of feedback here from all of your lines that are not muted. So the first question, what is gender identity? And what gender identity means is that is an individual's perception of having a particular gender. And the important thing here is that gender may or it may not correspond to that individual's birth sex. Another way to look at gender identity is one's innermost concept of self, either as male or female, a blend of both or of neither, and how individuals perceive themselves and what they call themselves. And that's some background that you just want to keep in mind while we're talking about these issues. Other important terms to keep in mind here while I'm going to explain to you what the best actions you should be doing as an employer are gender expression. because that's where an individual is going to want to be able to express their gender in the way they want. And what that means is the external appearance of an individual's gender identity. It typically is expressed through behavior, clothing, haircut, or voice. And importantly, that expression may or may not conform to socially defined behaviors and characteristics that are typically associated with either being masculine or feminine. And I'm going to talk about a Supreme Court case in a minute that really discusses all of those aspects. And then the term transgender, that's really an umbrella term, and it's for people whose gender identity and or expression is again different from cultural expectations and norms based on the sex they were assigned at birth. What I have here, a note bolded, is that being transgender does not necessarily imply any specific sexual orientation. Therefore, a transgender person may identify as straight, gay, lesbian, or bisexual. So courts that discuss transgender issues may not necessarily discuss sexual orientation issues. Once again, can everyone please mute their lines? I'm getting some comments that individuals are really having a hard time hearing the conference because individuals' lines are not muted.
It might be helpful to just take a quick look at your phone or at the computer and just make sure you have muted your line.
Thank you.
The conference has been muted.
Does that help potentially? If some people can make some comments, if that helps, that would be great. Okay, terrific. That hopefully should take care of the problem. Other important terms you want to pay attention to are gender transition, and that's the process by which some people strive to more closely align their internal knowledge of gender with outward appearance. And again, the transition sometimes is slowly, by dressing, by using names and pronouns, and we'll get to that in a minute, or undergoing physical transitions. And then gender dysphoria is a clinically significant distress caused when a person's assigned birth gender is not the same as the one in which they identify. So with all that in mind,
The conference has been muted.
With all that in mind, now let's get to actually workplace issues with those terms in the background. And as an employer, if these issues come up, you're going to have to deal with what policies you want to institute and practices you want to undergo while employees are transitioning. You want to figure out dress codes, certainly restroom protocols, name identification, discrimination and harassment issues, and then I'll talk about some best practices and policies. So what your obligations are under Title VII, which is the law that prohibits discrimination in the workplace, is Title VII bans sex discrimination. And what that means is that includes employees who may be treated differently for failing to conform to sexual stereotypes. And although transgender issues seems like a quote-unquote new issue, the Supreme Court has been grappling with these issues for quite a long time. The main case in this regard is still a case called Price Waterhouse versus Hopkins, and that was from 1989. And in that case, a senior manager who was female was denied partnership and then brought a claim for discrimination because the reason she was denied partnership was because she was known to be macho and wasn't as charming as a female should be, and didn't have her hair styled in a traditional female manner. And the court found that she had been discriminated specifically because of sex and sexual stereotypes. So that is really the basis for where this Title VII ban on sex stereotypes comes from. And now, recently, gender has been redefined to include gender identity, self-image, appearance, behavior, and expression. And in the past few years, the EEOC has specifically determined that Title VII prohibits discrimination based on gender identity. And notably, about a year or two ago, the U.S. Attorney General issued a memorandum that Title VII specifically banned discrimination because an employee is transitioning or has transitioned. Another thing I just want to note is that there's, by all accounts from what I've read, approximately 700,000 transgender individuals in the U.S. at this time. And more employers that I speak to are dealing with these types of issues in the workplace. So in the past 2 to 3 years, almost every federal agency, the EEOC, the Department of Justice, the Department of Labor, and specifically OSHA, which I'll talk about in a minute, have interpreted Title VII, like the Supreme Court did, to include discrimination based on gender identity or transgender status. In the past few years, the EEOC alone has recovered nearly $7 million in monetary relief for individuals claiming some type of gender identity discrimination. It was almost exactly 2 years ago that the EEOC issued a fairly important and precedential ruling that an employee cannot be denied access to common restrooms used by employees of the same gender identity. And perhaps because of that ruling, there was some backlash based on the law in North Carolina last year, and that ruling has really precipitated so much of the discussion about bathroom access for transgender individuals. I have here, I also just wanted to say there's a bunch of states that have transgender bathroom type specific laws, and I'm going to go through them very quickly. I'm not going to spend too much time on them, but if you are in a state that you see me just quickly reference, that is very important for you to be aware of what the state law specifically says and don't only look at what the federal EEOC or the courts federally are saying. Before I get to that, I just want to give a few examples of unlawful harassment, and this is where the courts are going. One that I've seen a few cases are a manager or a supervisor intentionally and or persistently failing to use the name and gender pronoun that correspond to an employee's self-identification. This is where training comes in. Those of you on the phone today hopefully will realize that if an individual expresses a preferred pronoun, that individual should be referred to by that pronoun. However, that needs to go all the way down to the managers and supervisors, because if someone says, I don't care what you prefer to be called, I'm going to call you by your God-given name, that could be a problem, and I have seen cases where that has occurred. And of course, the other big example of unlawful harassment that we've seen many cases is denying equal access to a common restroom corresponding to an employee's gender identity. And here are just some of the states. Colorado specifically sets forth in its statute that an employee must be able to use an appropriate facility, a facility that's appropriate to their gender identity. Delaware has a similar law. The District of Columbia, where Lindsay and I are located, specifically says that a single-stall restroom must have gender-neutral signage. Iowa, Vermont, Washington State all have similar laws as well. As I said, the transgender issue and the sexual orientation issue do obviously have a lot of similarities and kind of get grouped together. So for that reason, I did just want to kind of update you on what's going on also in the sexual orientation realm from a court perspective. And about 2 months ago, there was a groundbreaking decision in the Seventh Circuit, out kind of in the Midwest, where it's Chicago and Indiana. And that court, for the first time ever, an appeals court in the United States, held that discrimination specifically on the basis of sexual orientation is prohibited based on Title VII. In that case, a plaintiff, sued the college because the college failed to promote her for a full-time teaching position, and then ended up terminating her part-time contract. And she alleged because it was because of her sexual orientation, and the court allowed the claim to proceed. So this is not the law yet nationally, but again, it's the first federal court of appeals to rule this way. There are also numerous states that prohibit sexual orientation discrimination. But interestingly, approximately 1 month before that, an appeals court in the 11th Circuit, which is where Louisiana is located, and I believe Florida, specifically says that Title VII did not cover sexual identity. It stated that it does cover gender nonconformity claims, such as transgender, but that it did not prohibit sexual identity discrimination. So obviously, due to this split, unless we hear something from the legislative branch, which is probably unlikely anytime soon, this issue is likely to be resolved by the Supreme Court in the next few years. But going forward, what should you do with the bathroom question in your workplaces? It's interesting. OSHA in the past few years has issued guidance regarding restroom access, and they take the mindset more from a worker or employee safety perspective. And their guidance reiterates, and discusses the adverse health risks from potentially restricting an employee access to the bathroom of his or her preference. OSHA basically says that requiring a transgender employee to use a bathroom inconsistent with their gender identity may make them feel unsafe, and as a result, they could otherwise avoid using restrooms entirely at work. And this is also what happens in schools, too. And there's a big case that I'll talk about for a minute going on in a high school where the plaintiff really feels unsafe and avoids using the restroom at school, which, of course, could have adverse health consequences. So the model practices recommended by OSHA are to have a written policy ensuring that all employees have prompt access to appropriate sanitary facilities. One option is to provide slightly different bathroom options. One could be a single occupancy unisex toilet facility, or multiple occupant gender neutral restrooms with lockable single occupant stalls. An important thing I want to stress here is that if an employee tells you they're transitioning, do not ask the employee for medical or legal records of gender ID in order for them to get access to a specific toilet facility. That just is a stigmatization that there's no reason they have to provide medical documentation. Also, do not require transgender workers to use a segregated bathroom. Again, that alienates the individual. And again, from a kind of worker safety, adverse health consequence perspective, a restriction on access to a toilet must be reasonable and may not cause extended delays. Don't make an individual use a toilet in a different building or a 15-minute walk away. That is just not something that you should do either under OSHA or just generally as a prudent employer. And if you do that, not only do transgender issues become involved, also issues relating to the Americans with Disabilities Act can start rearing their head, and that is something that you always want to avoid. You know, if an individual who is transgender can also say that there were some sort of medical conditions they had that were ignored by their employer and caused a disability, then you're going to have a much bigger headache than you otherwise would have had. So some action steps I want to give for you. Potentially, if an employee comes to you and says they're transitioning, you may want to have a meeting with that employee, discuss what both that employee and the management expect through the transition process. The manager might also need to meet with the employee's supervisor and educate him or her about the process and review applicable company policy and procedures. There might also need to be a meeting with the employee and the supervisor. This is somewhat dependent on what the employee feels comfortable with, but it is important that at least the employee knows you are serious about discussing the transition plan with that individual and addressing any questions or concerns. It's possible, and I have a big question mark here, based on what the employee wants, that you might want to inform coworkers about the transition and, again, create an education component and an atmosphere where employees feel comfortable asking questions about their expected behavior. And from a policy perspective, you want to amend any non-discrimination and anti-harassment policies that hopefully you have to include gender identity and conformity with gender-based preferences, expectations, or stereotypes, potentially consider changing gender-based dress codes, and establish a gender transition protocol that has clear expectations for management and the transitioning employee and procedures for adjusting personnel records. And that is where personnel records are important, where it comes with a gender pronoun. If an individual has changed from a he to a she, the personnel records will need to be changed to reflect that. And again, you need to educate the workforce about transgender issues and what company policies are. If you have company policies, but your workforce isn't trained on those policies, it's as good as not having policies at all. Update your restroom and, if you're a club, locker room access policy. Add a gender-neutral or single-occupant option if that's at all possible. And again, use preferred names and gender pronouns of the employees. There are a bunch of cases here that are very interesting and important, but what I'll do is at the end I will send these slides to you, and then you can email me and ask any questions about these cases. But Lindsay and I have a lot to cover, so I don't want to spend too much time talking about any of these cases. This is the high school bathroom case that I mentioned. There's also a Planet Fitness case that just happened a few days ago where a member brought suit alleging that she was uncomfortable with the fact that there was a transgender individual in the locker room, but the court found that the employer had the basis to instill whatever rules they wanted, and since they had a transgender-neutral policy, it was lawful for the employer to institute that policy. So I just wanted to highlight that. There's a few other summaries of cases, again, that'll be in my slides that I'll send to you at the end of the presentation. But with that, I'm going to turn it over to Lindsay to talk more about pregnancy discrimination and Ban the Box.
Okay, so hello again, everyone. So pregnancy discrimination is another area of the law that can be particularly tricky for employers, particularly related to accommodation of a pregnant employee. Pregnancy discrimination is predominantly controlled by the Pregnancy Discrimination Act. And this is a federal statute that protects pregnant workers and forbids discrimination against those workers in any aspect of employment, like hiring, firing, promotion, benefits, based on pregnancy, childbirth, or any other condition related to pregnancy or childbirth. And this law may also require covered employers to make certain job-related modifications for pregnant employees. Specifically, the law requires employers to treat pregnant employees who are temporarily unable to perform their job functions or maybe limited in performing their job functions due to the pregnancy or childbirth or condition related to pregnancy or childbirth in the same manner as it treats other employees who are similar in their ability or their inability to perform their job duties. In addition to the Pregnancy Discrimination Act, or PDA, which I'll probably refer to it as going forward, the Americans with Disabilities Act may be relevant if an accommodation related to pregnancy or childbirth is requested. The ADA requires that employers provide a reasonable accommodation to employees with disabilities, so long as that particular accommodation doesn't cause an undue hardship on the employer. Although pregnancy alone is not a disability under the ADA, and that's something that's been specifically determined, and the EEOC has said that pregnancy alone does not constitute a disability. There are many pregnancy-related conditions that would be considered disabilities under the ADA, and that an employer would have to accommodate pursuant to the ADA. Some examples might be anemia, gestational diabetes, potentially severe morning sickness or swelling in the legs, and any other impairments that limit the normal function of a bodily system or that present high-risk complications such as like hypertension or diabetes related to the employee's pregnancy. So under the PDA, an employer that allows temporarily disabled employees to take disability leave, leave without pay, light duty, any other accommodation, must also allow an employee who is temporarily disabled due to pregnancy to do the same. Essentially, under the ADA, an employer is responsible for making job relation modifications or, in some cases, accommodations for pregnant workers when the employer does so for other employees who are similarly limited in their ability to perform their particular job duties or job functions. For example, an employer with a policy accommodating most non-pregnant employees with lifting limitations would also be expected to accommodate a pregnant employee who also has lifting limitations. In the same regard, an employer also cannot single out a pregnancy-related condition for special procedures to determine the employee's ability to work if they do ask for a modification. However, if an employer's policy requires that other employees in a similar circumstance provide a doctor's note or provide some documentation of their medical condition, they can also require an employee who is requesting a modification related to pregnancy or childbirth to do the same. In other words, an employer is not required to treat a pregnant employee any better than it would its other employees, but a pregnant employee cannot be treated any worse than someone who is similarly situated to her. Accommodations can include such things as, changing their schedule, the ability to take breaks throughout the day, the ability to have food or snacks at their desk, drinks at their desk, maybe a modified attendance policy, and then potentially light duty or the ability to, sit throughout the day or something along those lines. So the ADA is triggered when the pregnancy or the condition related to pregnancy or childbirth would meet the definition of a disability under the ADA. And disability under the ADA is defined as an impairment that substantially limits one or more major life activities. So if the condition related to an employee's pregnancy or childbirth does limit them in one or more of their major life activities, then the employer would be required to go through the same process that it would with an employee who has a disability under the ADA, any other employee who has a disability under the ADA, which would require the interactive process to determine what the accommodation should be, and then, ultimately implementation of that accommodation. And the specific accommodation would depend on the actual impairment. For example, if the employee has pregnancy-related hypertension or abnormal heart rhythms, this may require frequent rest breaks, or it may require an employer to allow intermittent leave so that an employee can go to doctor's visits or checkups related to this particular condition. And I just realized I'm a little behind on my slides, so sorry about that. But now I'm up to date here. So one of the most common questions that we get from clients related to pregnancy is whether they would be required to give a pregnant employee light duty. And as I've kind of gone over in previous slides, an employer is required to provide light duty under the Pregnancy Discrimination Act if they would allow someone who is similarly limited in their ability to take light duty. For example, if the employer has provided light duty to a worker complaining of lower back pain in the past, it cannot deny light duty to a pregnant employee who complains of lower back pain due to her pregnancy. An employer also cannot justify denial of light work duty to a pregnant employee if it has provided light work duty to others similarly limited, just because it would be more expensive or less convenient to make the accommodation. And that actually comes from the UPS versus Young case, which I will talk about briefly in just a minute. In the context of the ADA, light duty may be an appropriate, reasonable accommodation, again, depending on the employee's specific condition related to her pregnancy or related to her childbirth. So an important case on this particular question regarding light duty is Young versus UPS, which was ultimately decided by the Supreme Court in 2015. Specifically, in this case, the plaintiff had a medical practitioner, the plaintiff was pregnant, had a medical practitioner who advised her not to lift 20 or more pounds while working. UPS's employee policy at the time required its employees to lift up to 70 pounds and limited its light duty positions to specific groups of employees. And it was specifically 3 groups. Those that were injured on the job, those that had an ADA-covered disability, and those who lost their Department of Transportation certification, so drivers who lost their certification. As Young didn't fall within one of those groups, she was put on an unpaid leave of absence during her pregnancy and ultimately lost her medical coverage while she was on the unpaid leave of absence. So Young ended up suing UPS, and she claimed that she was a victim of gender and disability-based discrimination under both the Americans with Disabilities Act and the Pregnancy Discrimination Act. UPS argued that she couldn't actually show that its decision was based on her pregnancy or a condition related to her pregnancy, or that she was treated differently than any other similarly situated coworker outside of those 3 established categories to who they would provide light duty work. So in its decision, the Supreme Court held that a pregnant employee could establish a prima facie case of disparate treatment under the Pregnancy Discrimination Act by showing that she, 1, belongs to a protected class, 2, that she actually sought an accommodation, 3, that the employer ultimately did not accommodate her, and 4, that the employer accommodated others, in quotes, or others that are, quote, similar in their ability or inability to work. The Supreme Court also explained that an employer could refute this case if it could provide a legitimate, non-discriminatory reason for refusing to provide the particular accommodation. But again, the court emphasized that such reason could not generally be that it would be more expensive or less convenient to include pregnant women in the category of employees it would accommodate with light duty. And then if the employer could establish this legitimate non-discriminatory reason, the employee would have to show that this reason was pretextual, that it was really that they were discriminating against their pregnant employees to ultimately prevail in the case. So here, the Supreme Court determined that Young had established her prima facie case, but it ended up sending the case back to the Fourth Circuit to determine whether the justification provided by UPS, namely that it did not discriminate against her as a pregnant woman, but she did not fall within the categories of employees to whom they would give light duty, determine whether that justification was legitimate and non-discriminatory and ultimately sufficient to meet UPS's burden in the case. But UPS and Young ultimately settled the case, so the Fourth Circuit did not get a chance to make a determination on those particular facts. This type of pregnancy discrimination definitely remains a significant issue, as has recently been demonstrated by a pair of Walmart associates who filed a claim really similar to Young's in May of this year. This particular case has been filed as a class action pregnancy discrimination case, and it alleges failure to accommodate a large percentage of the pregnant workers at Walmart during a period of about a year, despite providing accommodation to non-pregnant workers who had similar physical limitations to pregnant employees. The suit specifically points to a change in Walmart's disability accommodation policy. Specifically, in the complaint, it's asserted that the Walmart policy limited modification for pregnant employees to those that would be, quote, easily achievable, and which did not, quote, have a negative impact on the business. But for non-pregnant employees, it was just, a reasonable accommodation if it doesn't cause an undue hardship to the company. One of the employees claims that she was put on unpaid leave as opposed to being given an accommodation that she requested. And when she returned, that she was actually put into a lower paying position, and the other employee had similar claims. So this is a little different than UPS, as it is a class action, and the class has the potential to be quite large, so it could be a substantial litigation. And it definitely demonstrates the significant impact that these types of claims can have on employers and their employees. So to help avoid potential claims of pregnancy or childbirth-related discrimination, employers should review their accommodation policies as well as their leave, scheduling, and attendance policies to make sure that pregnant workers are not disfavored in the policies and how the policies are implemented, and that they're treated in the same manner as similarly situated employees. If there are workplace policies that limit employee flexible use of certain benefits, such as leave or alternative scheduling, which, as I discussed, are modifications that an employer can make for a pregnant employee, the employer should make sure that these limitations are based on business necessity and that they, again, are applied in the same manner to all employees. If feasible, we do recommend providing temporary reassignment of job duties if an employee is unable to perform job duties due to pregnancy, childbirth, or conditions related to pregnancy or childbirth, to both address the needs of the employee as well as limit the possibility, of an employee claiming that they were discriminated against based on pregnancy. If pregnant employees will be taking leave, an employer should consider consulting with the employee in advance to address both the employee's needs as well as the needs of the business during that determined period of leave. While on leave, the business will have to cover the job functions of the pregnant employee. Usually you'll find that the impact of the employee taking leave is lessened significantly when preparation has been made to make sure that those needs are addressed. And then also ensure that employees on pregnancy leave have access to all benefits and opportunities made available to other employees, such as training. And then where pregnancy-related condition meets the definition of a disability under the ADA, the employer should ensure that there is a process in place to quickly consider a reasonable accommodation, engage in the interactive process, and ultimately implement the accommodation. Employers should also train supervisors on how to respond to pregnant employees' need for an accommodation and use of the interactive process. A manager should never change a pregnant employee's job functions or place her on leave based on the perception of a disability or impairment related to pregnancy. Employers can get into some trouble if decisions are made on behalf of the pregnant employee as opposed to in consultation and working with the employee. For example, it would be considered discriminatory for an employer or manager to take an employee off a certain account that requires travel because the employer or the manager decided that traveling was not within this employee's best interest. So in sum, employers should carefully review their policies, especially any policies related to leave time or light duty. This analysis is something that would take a significant amount of time and effort just based on the fact that there are a lot of different laws at play here. You have to make sure that the particular jurisdiction in which the employees are located, that employers review the laws in those particular areas as well. A lot of states and localities may have additional requirements and safeguards for pregnant women. For example, some states have their own laws regarding parental leave and pregnancy accommodation. And so where those additional state laws are also applicable, employers need to ensure that their policies and their practices and any training provided to managers also reflect those laws. All right, so another burgeoning area of anti-discrimination law is a set of laws that have been termed ban-the-box. And generally, ban-the-box laws will eliminate questions regarding criminal convictions and criminal history from job applications and push those inquiries to later in the hiring process. So there's a little bit of background on these laws. The EEOC actually put out some enforcement guidance back in 2012 regarding how employers should treat arrests and criminal convictions to avoid potential allegations of discrimination. And according to the EEOC, the use of criminal history, and sorry, just to be clear, EEOC is the Equal Employment Opportunity Commission. So according to the Equal Employment Opportunity Commission, the use of criminal history as a basis for a hiring decision can actually constitute race or national origin discrimination under Title VII due to the substantially higher rate of arrest for African American and Latino men, and thus the greater likelihood that those individuals will have a criminal history. Thus, policies and practices that permit an employer to make a hiring decision based on criminal history may actually violate Title VII because it results in those protected classes being treated differently than other similarly situated applicants. So relevant to this guidance is the fact that EEOC says that arrests and convictions should be treated differently, that arrests alone should never be used in the context of a hiring decision because an arrest does not show that criminal conduct actually occurred. However, the EEOC does concede that a criminal conviction usually supports the fact that a criminal act or criminal conduct has actually occurred. But even in that context, the EEOC states that the criminal conviction should only be used in the hiring process if it's related to that particular position or the job duties of that position. And to make that assessment, to determine whether it would be relevant to the particular decision, the EEOC suggests, or if the EEOC was pursuing it, would require that the employer look at the nature and gravity of the offense, the time that has passed since the offense, and the nature of the job that is being sought by the applicant. And this third factor is actually especially important, as the guidance, makes clear that there has to be a relationship between the conviction and the job position for that particular conviction to be pertinent to, the applicant and whether to hire the applicant. In recent years, there has been a lot of momentum for ban-the-box laws. Much of these requirements have been promulgated at the state or local level. Currently, about 9 states require removal of the conviction history question from job applications for private employers, although a number of other states have passed laws intending to impact the use of criminal history. And a large number of cities and counties have also implemented such laws. At the federal level, President Obama, during his administration, endorsed a ban-the-box by directing agencies to delay inquiries into job applicants' records until later in the hiring process. However, currently, there is no federal ban-the-box law for private employers at the federal level. So as I stated, ban-the-box laws usually require that the question regarding criminal history is removed from the application, but does permit those inquiries into an applicant's criminal past later in the process. Many laws also prohibit such an inquiry until after a first interview or until a conditional offer of employment has been made. For example, in Washington, D.C., as well as in New York City, employers cannot inquire about an applicant's criminal background until they have made a conditional offer of employment. These types of laws generally do create some exceptions for certain employers. For example, employers who are obligated to look at criminal history based on a federal, state, or local law, those employers would still be required under the state and local ban-the-box laws. They would still be allowed to ask those questions as necessary. Most of these laws also limit the circumstances in which criminal history can actually be used to make a determination whether to hire an applicant. For instance, again, looking at D.C., D.C. employers have to provide a legitimate reason to withdraw the conditional offer of employment based on an applicant's criminal history. And actually, similarly to the EEOC's guidance, D.C. employers have to consider certain factors in making that determination. And those factors include the time that has elapsed since the conviction, the specific duties of the position, as well as whether the prior conviction actually bears on the individual's ability to perform the desired position. An employer may, for instance, choose to withdraw an offer of employment to work as a financial planner for someone who has a criminal conviction for embezzlement or stealing funds. Due to a number of different laws on this issue at the local level as well as the state level, it's really essential for employers to know which laws apply to them and what those laws specifically require. Once that's understood, employers should review and revise their initial job application forms to ensure that those forms do not ask any questions about the criminal history of the applicant. Additionally, hiring policies and procedures should be updated to reflect not only the revised forms, but when in the hiring process an employer is actually permitted to ask about an applicant's criminal history. And then from there, employers should train their human resources personnel as well as anyone else who's going to be involved in the hiring process, conducting interviews, to ensure that no inquiry into the applicant's criminal history is made until it's permitted by the applicable law. For instance, in New York City, such an inquiry could not be made during the initial interview process at all because the inquiry can't be made until a conditional offer of employment is given to the applicant. And then after that time, the New York City law permits that an employer may ask about criminal history. Furthermore, those charged with making a hiring decision should be instructed that the decision has to be based on a legitimate business reason where the law does require that. They also may potentially have to consider certain factors like those required under the D.C. law in making their ultimate determination. So employers want to stay away from general exclusions of applicants with a criminal history. You want to make sure that individual assessments are being conducted of the applicant based on their experience and ability. If a criminal conviction is disclosed, the relevance of that conviction should be evaluated to see, if it really would impact the employee's job functions, the employee's particular position. You also want to document this evaluation. As I said, there are several ban-the-box laws that do require certain factors be considered. So it's important to make records of, the decision-making process, as well as maintain those records just in case the decision is ever challenged. And then outside of criminal history, it's also important to understand and comply with relevant laws on background checks, which does include the Fair Credit Reporting Act. And then finally, you definitely want to review handbooks. This is something that should be done frequently. Given the changes in several employment laws over the past couple of years, both on the federal and state level, employers should evaluate their policies to ensure that they are consistent with all current laws, including ban-the-box. If the handbook is updated, just make sure that it's redistributed, or at least the policies that have been updated are redistributed and have been added to the employee handbook. And then you want to make sure that you obtain acknowledgement of receipt of those policies or the new handbook from each employee. So with that, I will turn it back over to Jordan to finish it up.
Thank you very much, Lindsay. Before I get to just this last bit on social media, I wanted to answer a question. Someone asked about the 3 factors that an employer should assess in determining whether a conviction should impact the decision to hire. And those 3 factors are the nature and gravity of the offense, certainly the time that has passed since the offense, and probably most importantly, the nature of the job held or sought, to see if that the job being sought is related to the conviction. So as Lindsay said, if someone's in a financial, being considered for a financial position and they were convicted just a few years ago of embezzlement, that's probably a legitimate, lawful reason not to hire that person.
And just to add on to Jordan's point, those 3 factors are from the EEOC's guidance, and the particular state or local law may have some additional or different factors that an employer would have to consider if there is an applicable ban-the-box law.
Thank you, Lindsay. Okay, I'm going to move on to the last little bit here. We'll probably go a few minutes past 2 o'clock, but I know some of you will only have an hour, and right before 2, I'll make sure to send you in the comment box the webinar certificate that some of you need. But let's just go to the social media right now. Obviously, most of you know what social media is, Facebook, Twitter, blogs, LinkedIn. But what gets confusing here is that the National Labor Relations Act, and that doesn't just apply to unionized employees, it applies to all employees. And it says that these employees have the right to what's known as engage in concerted activities for the purpose of collective bargaining or other mutual aid or protection. And an employer policy or practice that restricts the rights of an employee to do so can be vulnerable to a charge of an unfair labor practice. And where this comes into head is, for the most part, Facebook posts. The NLRB says that employees have the right to use social media to engage in concerted activities, So as a result, if an employer disciplines or discharges an employee who has engaged in social media activities, potentially in the concerted action, or even if an employer has an overbroad social media policy and has not even enforced that policy, the employer could be liable. And I have here just some bullet points of activities that are not protected. And that is personal issues that don't impact others, spreading false information about the company's business, threats of violence, workplace harassment, unlawful use of companies' logos and trademarks, and a few others. Before I go any further, I just want to post this certificate for anyone who does need it, and it should be coming on your screen in your chat box momentarily. But on the other hand, back to employer policies, there are many policies that either the NLRB or courts have found overbroad and thus unlawful. And that is some of them here, and these are not all of them, but requiring posts to be accurate or not misleading. Requiring employer approval before posting is certainly unlawful as long as it's not on behalf of the employer. Forbidding rude, offensive comments or activities that would damage the company. Restricting employees from posting photos, video, or comments about the company. And in a minute, I'm going to get to the no recording policy. And prohibiting the posting of non-public or confidential information without any definitions. And where this came to a head is in the Chipotle case a couple years ago, where Chipotle had language that said, if you aren't careful and don't use your head, your online activity can also damage Chipotle or spread incomplete, confidential, or inaccurate information. That was in the employee handbook. It also said, you may not make disparaging, false, misleading, harassing, or discriminatory statements about or relating to Chipotle, our employees, suppliers, customers, competition, or investors. And the court found that Chipotle's warning not to spread confidential information on social media was unlawful because the word confidential was vague, and the employee could easily interpret the policy to prohibit conversations about wages and benefits, which is protected as other concerted activity. The NLRB also said that the prohibition on making disparaging, false, or misleading statements was unlawful because such statements could be shown to have a malicious intent on employees to think that they are losing the protections of the National Labor Relations Act. What I typically do as an employment lawyer is sometimes try to put a catch-all at the end that says nothing in this policy should be found to violate the National Labor Relations Act. But in this case, the National Labor Relations Board even said that such language was not was insufficient to cure the unlawfulness of those provisions. So this is really something you need to be careful about. I just read about a case the other day where a catering company in New York fired an employee for basically a rant he had on Facebook saying how much of a loser his boss was, and he used some colorful language that I'm not going to say here, and it seemed completely inappropriate. But it happened the day after a union election, and this was an employee who was arguing hard and trying to convince other employees to be represented by the union, and the court found that in that context, despite his vulgar and inappropriate almost threats on Facebook, they ordered the employer to rehire that employee. So these are things you just really, really need to be careful about when you institute your social media policies. And the last kind of point I want to talk about with that is no recording policy. And where this usually comes into play is if you have a cell phone policy in your employee handbook. And as part of your cell phone policy, you might have something that Whole Foods had, which they said that in order to encourage open communication and a free exchange of ideas, when you're in the workplace, you are not allowed to unilaterally use your cell phone to just record conversations, record your boss, record your supervisor, record other employees. And the Second Circuit, so the New York court, just ruled and affirmed the NLRB's decision finding that Whole Foods rules prohibiting the recording of company meetings or conversations in the workplace, that rule violated the National Labor Relations Act. Again, the NLRA protects recordings if an employee is acting in concert for mutual aid or protection of an employee, and the court ruled that there was no overriding employer interest in having this no recording policy, and that the employee may in fact have a reason to record something. Maybe that he wanted to document unsafe workplace equipment. Maybe he wanted to record evidence to preserve it for later use in a lawsuit. Maybe he wanted to document inconsistent application of company rules. Maybe it was for workplace safety. So there are all these issues that just a blanket policy doesn't cover. So what the court said was, we're going to be careful here. We're not just going to necessarily say that every single every single policy that places limits on recording audio and video in the workplace is unlawful. What we're going to say is if there is a no recording policy, it needs to be narrowly tailored and reasonably limited to an actual concern an employer has or an actual legitimate policy and reason to institute it, and so that it doesn't curb an employee's rights to engage in concerted activity. So we've worked with clients based partly on this, not the Second Circuit decision that just came out a few days ago, but the NLRB decision that had come out last year, to craft policies that both protect the interest of the employer, but also that don't run afoul of the law and don't get you into trouble. I could go into a lot more detail on this, but I don't like to keep you here for more than an hour. But these are just, I wanted to kind of introduce this topic and really get you thinking about these issues when you are drafting your employee handbooks, when you're trying to really enforce your no cell phone or no recording policy, when you hear about employees who have potentially inflammatory posts on Facebook. So you at least know, shoot, there are some issues here. We can't just have a knee-jerk reaction and fire the employee, and call legal counsel and have a discussion on what is or is not permissible under the law. Just so you know, in case any of you on this line do not subscribe to our blogs, we have two blogs here, the Employer Defense Report and the OSHA Defense Report, that we talk about these issues all the time. Anytime a new law comes out, anytime there's a legislative process, legislative action on any of these issues, we write about it for you guys. So if you ever just go to these blogs, you can sign up. It's free, and every week or so you'll get a message in your inbox telling you we have a new posting, a new article, and it's good for you to just keep abreast of the law, of what's going on in this area without needing to research it on your own. So I highly suggest you sign up for that, just as an educational tool. And finally, here is both my email address and Lindsay's email address. I know there are a few other questions that we haven't gotten to, but at this point we've gone over our allotted time, so we're going to have to go. But please feel free to email me or Lindsay with the questions. And if you're having any difficulties with the webinar certificate, also please email me, and I will make sure to figure it out for you so you get the certificate and the credit you need from this webinar. And with that being said, Lindsay and I would like to thank you for your time listening. We hope you got something out of this, and we look forward to talking to you at our next webinar in July. Thank you very much.